guys ready to go, right? Yes?
I'll get it back to you.
Okay, good morning, welcome back. Please be seated. Okay. We ready to go?
Yes, Your Honor, some scheduling real quick.
Go ahead.
Captain Bonafair is here. Sergeant Matson is on her way. And Mr. Shihade had an emergency and will be here at 11:30.
Okay, but we have other witnesses we can put on.
We have one starter here right now, and like I said, Sergeant Matson should be here, I would say, within 20 minutes.
Okay, great.
So we might need an early lunch.
Yeah, we'll just play it by ear.
I think we'll be done early today. It's our last witness in the bill until tomorrow morning.
Who's the last witness?
Dr. Walker, I believe.
All right, we'll have to talk about that this afternoon. In any event, okay. So we've got witnesses ready to go right now. Let's go ahead and bring out the jury. All right, counsel may be seated. Welcome back, ladies and gentlemen. Next, we're going to call the next witness.
Yes, Your Honor. Defense calls Captain John Bonafair.
You can read those things.
Good morning, sir.
Morning.
Can you please state your full name and spell your last name for the record?
John Bonafair, B-O-N-A-F-A-I-R.
And who were you employed by?
City of Boynton Beach.
Were you involved in the investigation of Dalia Dippolito?
Yes.
All right, and at the time of the investigation, what was your position?
I was a sergeant in charge of the community action team.
Is that a specialty unit?
Yes, it is.
All right, and what does that unit entail?
Narcotics investigations, street crimes, things of that nature.
So basically, or pardon me, would it be fair to say it's a surveillance unit?
Yes, that's correct.
And was your team responsible for wiring Mohammed Jihadi at the Chili's restaurant?
Yes.
And did you personally wire him?
No, I didn't.
Were you there when he was wired?
No, I wasn't.
And at some point, you learned that Mr. Jihadi's wire malfunctioned.
Yes.
All right, and were there other ways that he could have been recorded?
Yes.
And can you please explain to the jury what other methods could have utilized that day?
We had a couple of different key fobs, watches, even a small digital recorder that we used to record a conversation.
And do you remember who told you it malfunctioned?
I believe it was Officer Reinhold.
And this might, I guess, seem like common sense, but when an interaction is not recorded or when it's not videotaped, there's no way to know what was discussed, right?
I really wouldn't want to speculate on that particular.
In general.
That'd be correct, unless there was an undercover officer.
And in this case, there was no undercover officer inside Chili's.
That's my understanding. Correct.
All right, in this case, Detective Marino was the lead detective.
I don't know if he was the lead detective or Sergeant Ramsey or Sergeant Sheridan was in charge of it.
All right, so you don't know if Sergeant Sheridan was running the show.
No.
But had Sergeant Sheridan been the lead sergeant in this case, that would have been his decision as to what device to be used.
Yes, I would imagine so.
Nothing further, Your Honor.
Cross-examination.
Good morning, sir. How are you?
Good morning.
When you say you're in charge of the CAT team, that's the community action team?
Correct.
Okay, and you guys are in charge of undercovers, doing a lot of undercover work, right?
Right.
Probably primarily drug buys.
Our focus is mainly on drugs, yes.
You also were in charge of undercovers, correct?
Any undercover officer would have been in my unit, correct?
Okay, and in this case, you were approached for an undercover to be used, right?
The Detective Bureau approached me several weeks before to provide an undercover officer for this particular case.
And so it was your selection to choose Woody Jones, right?
Yes.
He worked for you, worked under you?
Yes.
You had used him before as an undercover, correct?
Yeah. Yes.
And he had worked out well, right?
Yes.
Objection, relevant judge.
Want to approach?
And Bolster.
Is it the CAT team or your unit? Do you all handle all of the wires, different, I guess, tools that can be used?
We were the only unit at the time in the police department that had those items.
Okay, so if somebody wanted to do undercover surveillance or wire someone or record someone, they needed to come to you, right?
That is correct.
Okay. Wouldn't it be true that Sergeant Ramsey could have gone and gotten, you said that, let me strike my question. You said that there were key fobs, watches, other things that could have been done to record this interaction at Chili's, correct?
Correct.
Sergeant Ramsey could have gone and gotten those himself, correct?
He would have had to see myself or Carlos Reinhold, but yes, he could have come to us and we would have given him those items.
Okay. Sergeant Ramsey ever call you and ask for one of these things?
No.
If a wire fails and you have a CI in the middle of an interaction, let me back up for a second. In your career, kind of get ahead of myself. In your career, how many confidential informants have you worked with either directly yourself or in a supervisory capacity?
Probably over 300.
Okay. Is it acceptable practice if a wire or your recording device fails to debrief that confidential informant after their interaction?
Yes, that would be normal procedure.
I have nothing further. Thank you, Judge.
Redirect.
Agree with you, Judge. A couple of quick questions. At a previous hearing, you testified that the lead sergeant was Sergeant Paul Sheridan,
Yes, I believe so.
and you also testified that, pardon me, in regard to Sergeant Ramsey providing a device and Sergeant Sheridan being the lead detective, that the buck would have stopped with Sergeant Sheridan, right?
Overruled.
In other words, the final decision in an investigation goes to the lead detective and the lead sergeant, right?
I would say the lead sergeant.
Okay, and that's Sergeant Sheridan.
I believe so at the time. That's what he was in charge.
Nothing further, Your Honor.
Okay, you may step down, thank you. Defense, ready to call this next witness?
One moment, Your Honor. I can step out for 1 second.
Yes.
All right, move approach.
Yes.
Just wait for him.
Sorry.
little scheduling issue, that's all. Our next witness will be here shortly. We're just going to give you a 10-minute break. And instead of sitting here in awkward silence, we're going to go ahead and send you into the jury room. Let you relax. As always, do not discuss the case at this time, but we'll see you back in about 10 minutes. But they're only going to the jury room, so if he's there in 5 minutes, we'll get started. All right, maybe seated. Mr. Roosevelt, as soon as your witness is here, just let Deputy Cascone know. He'll come and get me, and we'll get started.
Yes.
Okay.
Yes.
Go ahead and bring out the jury. Counsel may be seated. Welcome back, ladies and gentlemen. Defense ready to call its next witness.
Yes, Your Honor. Defense calls Sergeant Carrie Ann Matson.
All right. May proceed.
Good morning, ma'am.
Good morning.
Can you please state your name and spell your last name for the record?
Sure, my name is Sergeant Carrie Ann Matson, M-A-T as in Tom, S as in Sam, O-N.
And Sergeant Matson, who are you employed by?
City of Boynton Beach.
And what's your current position with the City of Boynton Beach?
I am the sergeant in charge of records.
All right, and back in 2016, did I send you a record request for all maintenance records for maintenance logs pertaining to recordings from July 2009 to 2011?
Correct.
All right, and you forwarded that to Tech Support Communications and Evidence, right?
Correct.
And there were no records conducive to my request regarding broken surveillance equipment from August of 2009?
Correct.
Overruled.
All right, I'm now showing you Defense Exhibit, I believe it's 8, which is an email you sent me on May 3rd, 2017. May I approach the witness?
Yes.
Please take a look at this, review it, and let me know when you're done.
Okay.
And do you recognize this email?
Yes, I do.
Is it a fair and accurate depiction of the email you sent me?
Yes, it is.
And that email was, was regarding maintenance logs and reports pertaining to equipment malfunctions on surveillance equipment from July 1st, 2009 through April 21st, 2011.
Correct.
And can you please read your response to the request?
No records exist.
All right, Your Honor, I'm now moving to Defense Exhibit 8 in evidence.
Is that 8? Is there any objection to 8? I'm sorry? No, sir. Okay, defense 8 in evidence without objection.
No further questions, Your Honor.
Cross-examination.
Ma'am, are you aware of the procedure of what happens if there's broken equipment?
A little bit, yes. It depends on what the equipment is. Stuff like our $1 million CAD system or our generators and stuff would have maintenance logs where we would track, and vehicles would track, stuff that needs to be done for maintenance, like an oil change or change out the gas and stuff like that, or repairs that need to be done on it. Little items, stuff that's like $20, $30, $40 wouldn't keep a maintenance log, other than, they just change out the batteries when the batteries run. After that, they're usually just destroyed, and they go out and purchase another one.
Okay. Do you have knowledge as to whether there's records kept or requests made as far as surveillance equipment that's malfunctioned?
No,
You don't know, or there is not?
there is not to my knowledge.
So if malfunction,
No personal knowledge, Judge.
Overruled.
if there was a malfunction in surveillance equipment, would a request be generated to fix it?
Well,
And a log kept of that?
The equipment would be $20, $30. There wouldn't be a log to request it to be fixed. It would be cheaper to buy a new one than get a $20, $30 recording device fixed.
Okay, thank you, ma'am.
All right, redirect.
But you have no idea what happened to this wire, correct?
I wasn't working that day, no.
So what you just testified to was pure speculation?
I guess, yes.
Nothing further, Judge.
All right, you may step down. Thank you. Roosevelt, you want to approach for just a minute? Okay, that was basically a scheduling discussion. We got a few issues we have to take up, so we've got a plan. The plan is going to be, we're basically going to break now until 12:30, but we're going to, as soon as we get back, go ahead and eat. I know it's early for lunch right now, but if you, at 12 o'clock, and get something to eat, because we're going to go at 12 o'clock, or at 12:30 with the next witness. There's a chance we might finish up early this afternoon, though, but we want to get that witness on at 12:30 and get that done. So we're going to give you a break at this time. It's a little early, I realize that. We're not going to need you back till 12:30, but go ahead and eat something while you're out, or get a snack at least, because we are going to take up a witness at 12:30. Obviously, we're going to let you go. You can go out. Do not discuss the case with anyone, including any discussions amongst yourselves. Do not do any research. Do not listen to or any news accounts of the trial. We'll see you back at 12:30, and we'll get our next witness on. All right, counsel may be seated. All right, well, when he gets there, just make sure he knows he needs to stay till 12:30. I did, pursuant to his request, prepare a letter basically saying he was subpoenaed for today and needs to be here. I addressed it to whom it may concern. If he wants it addressed to somebody else, that's fine. But I did prepare a letter for the witness for his employer. Anything else we need to do before we break? There's nobody here.
I just rather everybody for sure.
Anything else? Mr. Williams, you look like you had something you want to say.
I know you ruled on the poisoning. You excluded that. I want to ask the court to revisit that now.
Okay, on what basis?
Mr. Chicago, that testifies to this is his statement. He's honest and if you look, start at the bottom of page 12 and on top of page 13, based on the information he's provided, they absolutely made this relevant. This is another issue of the defendant intending to kill her husband.
This is his statement,
That's his statement about the defendant's words to him.
and this was done on August 10th.
August 10th of 2009. Yes, sir.
Okay.
Your Honor, first, the state agreed to exclude this evidence. It was an unopposed motion, and Your Honor ruled on it. It wasn't a relevance issue, it was a 403 issue. So Mr. Williams just said, well, it's relevant now. Well, I mean, Your Honor didn't say it wasn't relevant. Your Honor said it was unfairly prejudicial. As did Judge Colbat, as did Your Honor in the last trial. This is consistent with being excluded under 403. Secondly, the bigger issue with that testimony is the reliability of it. There were 4 different versions that Mr. Salmi pointed out. One was he thought it was iced tea. One was it was hot tea at Starbucks, I believe. And it was all over the place. I mean, this is a completely incredible story that both judges have found to be unfairly prejudicial. The state has agreed to be unfairly prejudicial. And then an hour or 2 hours before his testimony, we're sandbagged with this judge. I mean, this is completely inappropriate. We're not prepared to address this if you're not recommended. And then this is 7 years, or pardon me, 8 years of the state agreeing this is a 403 issue.
I'm a little concerned that we're raising it now, frankly, Mr. Williams.
But what's different about that than the fact that she tried to hire people over here at Beach in March 2009?
Candidly, I'm not sure there is, but I'm a little concerned that we're raising it now. I mean,
It's raised now, Judge, because of all the traffic stuff they've been talking about. They got out there with this expert yesterday and said that they were putting the ideas in her head, that what he's done was, and that Mohammed Shahadi put ideas in her head. That is completely contrary. They made it relevant now, and that should be admitted into evidence. That is critical evidence against the defendant showing that she's the one that came up with the ideas to kill her husband.
Because that doesn't change the 403 issue. The city never said it wasn't relevant. They said it was unfairly prejudicial. So,
well, let me ask, how is it, obviously a prior attempt to kill goes to motive intent, so it's clearly relevant. What's the 403 analysis? Because you're right, they agreed to this before, and I granted it based on that. I never really heard any argument about it before. So what's the 403
I wasn't
analysis?
calling Mohammed Shahadi as a witness, Judge. I had no intention of calling him, so the only witness we had was the victim. And the victim, all he knew was that he drank tea that tasted him like there was something really bad with it, spit it out. That's the only evidence we had. So we were standing on that. The fact that they're calling him now, I'm going to question him about that, about what the defendant said to him. And now I can put it into evidence. Now it's absolutely relevant. They've made it relevant. They've made it a key issue.
what does he not get about relevance, Judge? They never said it wasn't relevant. The state agreed.
No, but we both agree it's relevant. My question is, because I never heard, well, I think it's relevant. Your whole position is they manufactured the crime. It wasn't her idea. It's a manufactured crime. So it's relevant. The question is the 403. That was my question. I believe it's relevant. It's probative to an issue in the case.
I asked for a ruling on, this wasn't a stipulation, I specifically, because of the crimes issue last trial, requested a ruling on each, including on the post motion before trial.
Okay, but even if,
And Your Honor ruled based on 403. I said, what are you basing this on, relevance or 403? Your Honor said based on 403.
even if I rule, again, it goes back to the whole thing. On a motion in limine, you can always, a motion in limine is a preliminary ruling that can always change during the course of the trial. So let's talk about the 403. That's what I'm looking for. I'm trying to get a discussion from the attorneys about the 403 aspects of the case. It's clearly relevant. It's clearly probative. It goes to motive, intent, predisposition, and to defeat the defense theory of the case. So it's relevant. So talk about the 403. The 403 analysis is the probative value of the evidence outweighed by the risk of unfair prejudice. That's...
Well, Judge, first of all, and unfortunately, we're being sandbagged with this. I don't know why they're bringing it up now. They'd known we were calling Mr. Shiotti. He was here yesterday. I don't have my notes in front of me regarding his different stories. But part of the issue in the last trial, or pardon me, in the first trial, was how incredible his story was. I mean, there were so many different versions of what happened and so much uncertainty as to what happened that, I mean, the probative value was that minimal. You know, when a story is that...
That's a weight and credibility issue.
It's for the jury to weigh.
What is the unfair prejudice?
The probative value is measured, part of it, by how strong the evidence is. If it's weak evidence, it has the probative value is minimized. Secondly, how could it not be unfairly prejudicial when 2 hours before our witness testifies, 2 hours before, to a issue they agreed to, they've agreed to for 7 years, they agreed to, or being sandbagged with. That is utterly disingenuous, Judge. We are completely prejudiced. We haven't had time to prepare for this issue. We haven't had time to question Mr. Dippolito on this issue, which is most important, because he has given 4 different versions. So we can't backtrack now and go back to Mr. Dippolito and question him on the different stories he's given about it. I mean, if it would have raised this before trial, we would have crossed the heck out of him. Mr. Claypool would have gotten up here, he would have said, I'm not done talking, Judge. I mean, I appreciate a little courtesy here. I mean, he is told, and then they call him on rebuttal for us to cross-examine him to draw more attention to us. I mean, this is a complete due process violation. I mean, this is beyond disingenuous, Your Honor. Beyond.
One still address the 403 form.
Your Honor, may
Mr. Claypool, you want to address that
respectfully.
form?
There's been a mountain of evidence in this case already presented by the state that Ms. Dippolito not only had a clear and overt motive to kill her husband, but that she had actually done a lot of things to have her husband, for example, put in jail by allegedly planting drugs in his car. We've got information about Larry. The jury's already heard a mountain of evidence that Ms. Dippolito not only wanted to kill her husband, allegedly had a motive to kill her husband, but had actually talked to somebody else about killing her husband. So this evidence is merely an attempt to demonize and get this jury to hear that one fact. So when they go back, this is the prejudicial part, Your Honor. They will go back into that jury room. They will never be able to get beyond an allegation now that she tried to poison and kill her husband. And the evidence is not even, although the court finds it relevant, it's completely unreliable to allow this in at a late juncture. For example, we've heard zero testimony. You'll hear zero testimony from a police department even investigating this. The Boynton Beach Police Department didn't even know about this information at all during the investigation of Dalia Dippolito. So with that said, it's just an attempt at the end of this trial to get this jury to think she's a murderer. It's taking them off what this investigation was about. Now if this jury had no evidence of Ms. Dippolito having a motive, or she had actually tried to carry out a murder of her husband, then maybe the court might reach a different conclusion. But there is only one sole reason to bring in this evidence, and that's the prejudicial part of it. This jury hears this, they will never, they're not even going to consider the evidence we put on for the last week and a half.
And we can't question
I don't weigh the evidence as to whether they've established in the trial. I mean, I'm not weighing the evidence they've put on so far to determine whether they have determined sufficiently that she had a motive to kill her husband. I mean, I'm just evaluating, is it relevant? And is the relevancy basically the probative value outweighed by the risk of unfair prejudice?
Right, and I thought I addressed that respectfully. I'll try it one more time. If this jury hears this evidence, the prejudicial effect on Ms. Dippolito, she will be found guilty in 5 minutes if the jury hears it. There's no question about it. This is just a flat-out attempt to demonize her and characterize her as a killer. And there's already been evidence in this case. Your Honor just mentioned motive, but I just went beyond that. We already have evidence of Larry, and she's going to get a gun, do it herself. She's going to get her own guys to do it. We already have that. The jury's already got that information. This is piling it on, and the prejudicial effect of this is just is beyond comprehensible.
But your whole defense in this case is that they manufactured the crime.
That's not true, Your Honor. That's not true at all.
Significant part of the case.
That's part, no. Our argument, and most of Tim Williams talked about yesterday, was violation of police procedures, violation of directives. And by virtue of violating those police directives, the Boynton Beach Police Department was in essence escalating a situation. That's not entrapment. We're not saying, and I said this at the beginning of this, we're not saying, and I said this before the case started, manufacturing a crime is picking on a woman that didn't do anything and you're just trying to get her to do something. That's not what we're arguing. We're already facing a mountain of facts that this woman had a motive to kill Mike Dippolito, and in fact, Mr. Williams did a nice job of getting in the Larry evidence about her, trying to do it herself. So we're not saying they created something that didn't exist. What we're saying is they took a situation, they escalated it, they could have handled it differently based on the information that was communicated to them by Muhammad. So that's much different than just manufacturing and creating a crime. And then we also added the component of Cops Television Show, where people act a little differently when they got cameras rolling. That's not necessarily manufacturing something, that's compromising the integrity of the investigation. That's the cornerstone of the case, compromising integrity of the investigation, not creating a crime or just creating some fictional crime. That's our argument in the case.
In
It's
opening,
called two witnesses to testify.
hold on a minute, I want to say,
Yes, Judge.
in opening, you said they manufactured this crime and they took advantage of a vulnerable woman. That's what you said.
Let me clear that up. I said they manufactured the crime for television, the component of television. People acting different. They're scripting this for television. That's not entrapment, and that doesn't bring in this evidence. I mean, there's ample evidence in this case of violation. This is not a proper police investigation. There are protocols in place. Police departments have to follow certain protocols. They haven't followed those protocols. That's the cornerstone of the case. When I say manufactured, that might be an adjunct to the case, but that's not. Why would I be having all these directives, Your Honor, in the case? So I don't think the fact that I mentioned one time that they manufactured a crime, that now opens the door to this fantastic comment about poison and her trying to kill her husband. It's just completely prejudicial to Ms. Dippolito. It's just an attempt by the state to demonize her and get that jury to hate her so bad that when they get back there and deliberate, they're not even going to consider a week and a half of facts. They're just going to be talking about poisoning her husband. And that is reversible error if this gets in. That's my opinion.
And Your Honor, if I can just add one thing.
You guys thought of reversible error before, so.
Your Honor, if I can just add one thing. First, we called two witnesses today. Both of them testified to lack of evidence. Sergeant Ramsey, the crux of his entire testimony was the mistakes they made compromised the integrity of the investigation, being lack of evidence. Like I said before, we don't know if she was entrapped because they lost this evidence. I mean, that's the issue here. That's always been the issue here. My voir dire, 90 minutes, Your Honor called me forward. I made everyone discuss that by violating policies, violating rules, losing evidence, they were compromising the integrity of the investigation. It is a reasonable doubt loss of evidence case. Now let's put that aside for a minute. More importantly, not only could we not question Mike Dippolito about it, we could not question Officer Moreno about it. We could not question Detective Ramsey about the investigation of this poisoning allegation. We couldn't address it in opening. I mean, had this not been an issue the state agreed to prior to trial, unopposed, I mean, we could have structured our case differently, but now we can't. We are so prejudiced by this judge. I mean, we might have changed our theory. We might have changed our direction. We might have known for months this was going on. We might have reached out to other police officers to see what investigations they did. We've done nothing to prepare for this allegation based on the state's representation, which clearly means nothing. For 7 years, 8 years, it clearly means nothing. And the fact now that two judges have found that this is unfairly prejudicial, have ruled, and Your Honor did rule that, because I did ask for a ruling on which ground, and Judge Colbath even revisited it and said, you know what, this is unfairly prejudicial because I believe there was a renewed motion pertaining specifically to the poison. I mean, we're just getting sandbagged in the middle of our case. Our entire defense is prejudice.
Ms. Williams, quickly.
Just real quick, Judge, their police practices expert yesterday said two specific things that make this, you should rule this dismissal. One, he says the call by Willie G on Shahadi to the defendant for ideas okay. He said that. Number two, I asked him about the fact that she was short on the email, about 5,000% short, and he said that was just being some shit by the defendant. Those two things absolutely make that relevant. I'm entitled to put that evidence and show it to corroborate, to contradict what their experts said on the stand yesterday.
Your Honor said it was relevant 10 times. He keeps arguing relevance. It's not relevant. It's a 403 issue, and it's us being sandbagged.
I've heard all I need to hear at this point. I'm going to consider, look, you guys are giving me this the first time in the middle of the trial, so I need a little time to think about this. We've got a little bit of a break. I'm going to take this under advisement. I'll let you know what we're going to do when I get back. So I'll let you know at the end of the break. I need to consider this. It's an issue that is obviously extremely important, but it's being thrown on my lap. about an hour before we have the witness take the stand. So I need some time to think about it. I'm not going to shoot from the hip on this. All right, we're in recess.
Okay, folks, we're going to recess now.